we get started? I think these are live. Okay, well, why don't we get started? So welcome everyone. Thank you for being here on a Friday. This is a really special double treat to feature on the same stage for the very first time. Two old friends, two self-described troublemakers. Okay.
Thank you so much.
Judge Jed Rakoff, Judge Nancy Gertner, retired, teaching at Harvard. Both have been very, very active in the challenging world of forensic evidence and the judicial review gatekeeping regarding scientific evidence in criminal cases. That's our topic. We're having a whole gathering and conference sponsored by Bulge, by the Wilson Center, by CSAFE, the Center for Statistics and Applications in Forensic Evidence. We're all here today to talk about something that's pretty momentous, an amendment for the first time in 23 years to Rule 702. I have some questions for our two guests. I want you all to share questions with us too. I'll ask a few questions, but I hope you all raise your hands and chime in. And by you, I mean our students here at Duke. So we want you to impress our judges with your questions. But I'll start with a few questions to kind of introduce you to their work on forensic evidence from the bench and in the case of Nancy Gertner, off the bench. So to be a little bit chronological here, I want to ask both of our guests to think back to the days before they were robed and how they thought about...
And now I'm disrobed.
Yes,
Great.
now you're disrobed. But even before that time, how did you think about expert in forensic evidence when you were in practice before becoming a judge? Because both of our guests had extensive practice before taking the bench, which is a very good thing. Do you want to start, Nancy? And
Well,
talk?
So I knew I was a criminal defense lawyer and a civil rights lawyer. And on the criminal defense side, it meant, for example, if you had a case involving handwriting analysis, there was a woman in Boston who was the handwriting guru, and you'd go to her and she said, before you say anything about your case, I have two questions. Which side are you on and how much are you going to pay me? And it was perfectly clear then that her entire opinion was going to be skewed by those two questions. So I knew a great deal about forensic evidence. At the same time, because I started practicing, I was doing murder cases before I knew where to stand in a courtroom. That's a whole other discussion. I went to forensic and I went to experts to ask about what to do. Not legal experts, but I went to experts. And the first thing I recall is going to Michael Sachs, who's a social psychologist, very well known, writes about all sorts of issues. There was a rule, as those who've taken evidence, that you can introduce prior convictions when the defendant takes the stand for impeachment, not for substantive purposes. And I said, I want to challenge that. And so Sachs was my expert to talk about how, to a jury, it makes no meaningful difference whether prior convictions are coming in for impeachment or whether prior convictions bear on the substantive issue of whether the guy likely did the crime. And I used him as a psychological expert testimony for that. So on the one hand, I had substantial experience in exactly how to manipulate my experts, and I had substantial experience using bona fide experts to actually try to change the law. And that then certainly informed when I got on the bench in the first handwriting case I had, I knew, as my son used to say, that it was bullpucky. That's a legal term. Right.
So similar experience, but first I want to say I'm delighted to be here and especially have a chance to talk with the law students. I remember when I was a law student, I still feel the pain. I was a prosecutor for 7 years and then a criminal defense lawyer for 15 years. As a prosecutor, my experts were people who had always testified for the expert. I knew exactly for the government, and I knew exactly what they were going to say, and they were very experienced. When I became a defense lawyer, I would go to organizations, companies like NERA that provided experts. So I never had to say to an expert directly, I want you to come out this way. I would say to the company that was getting me the expert, I want you to get me someone who will come out this way. And then they would know who to supply. And to be frank, when I met the expert candidate, I usually talked to them about how to talk to juries and very little about the substance of what they were saying. I wanted someone, for example, I did not, practicing in New York, I didn't want a Harvard graduate. That would be disgusting. That no jury in New York would ever relate to that person. But if they had a degree from Brooklyn College, all right. And then we would talk about, how to look the jury in the eye, but not so much that they felt intimidated. All sorts of stuff that had absolutely nothing to do with the merits. And that, I think, is still often the case of experts I see in my court. So
let's turn to in court. So as judges, how did you first start? So you mentioned first handwriting case. Like, are there particular formative cases that caused you to become more engaged with these questions about the gatekeeping of forensic evidence?
Well, I think, this actually says something first about who you put on the bench. So it mattered that Judge Rakoff and I had substantial trial experience, and in particular, criminal defense or even criminal prosecution experience. That made a difference. So I came to the bench and I used to teach evidence, still do, and so I came to the bench with a framework. And the first case in which this issue came up is a case called U.S. v. Hines, which was an idiot bank robber who, really, these stories are extraordinary, who came into the bank and wrote, "This is a holdup," and then he didn't like the way he had written that, so he scrunched up the note and put it in the trash and wrote another one.
Oh, there you go.
Right, and handed it to the teller. And so there was a handwriting analysis in the case, and there was also eyewitness identification. He was a person of color, and the tellers identified him. The issue came up, the lawyer had not litigated anything when the case began, but it was a mistrial. So I knew there was going to be another trial. The government was going to go forward with another trial. Peter, if that happens in my courtroom, you'd be thrown out. Just want to say, yeah. And I knew that I created an occasion to write an opinion, which rarely happens at the trial level in a criminal case. Most of the time, as in that first trial, you're dealing with the case as it comes along and you're doing the best you can. But I knew that there was going to be a second trial, and so I wrote an opinion. I wrote an opinion that said, ironically, the old science, quote science, the old evidence, which was the handwriting analysis, seemed to me to be jive. I don't put it in that word, but it seemed to be, and I would exclude it, but I would allow in an eyewitness expert who would talk about the issues with cross-racial identification. And I wrote an opinion about that, and that really set me off on what are the kinds of occasions, made me look at how those who know the case the best, which is the trial judge, rarely has the occasion to write the kind of formal opinions that you might write with respect to a motion to suppress. And so it meant then that the law was being crafted by the Court of Appeals that is reconstructing an imperfect record. And so I then began to write opinions on ballistic issues, on arson questions, and it shaped what I did.
So, in the broadest sense, I was hugely impacted by the development of DNA evidence and also by the creation of the Innocence Project. Peter Newfield, one of the founders of that, is here because DNA, which had been put together by scientists, showed by comparison how weak most other forensic science was. Later, this was documented at great length by the National Academy of Science in their 2009 report. But even before that report took effect, just seeing the difference in my court between the DNA evidence and the other forensic evidence was like night and day. And the Innocence Project showed how totally innocent people could be convicted of the most serious crimes based on that other forensic science. There were other reasons they were sometimes convicted as well, but a substantial number of those wrongful convictions occurred in cases in which forensic science had played a material part. So that was very mind-opening to me. And then, with apologies, I have to say I was also influenced. There was this judge up in Massachusetts who kept writing these oddball decisions that I found quite persuasive. And so the first time I wrote an opinion as opposed to making rulings was in a case called Glynn, and I expressly acknowledged, and rightly so, my debt to Nancy for showing me that.
That's Judge Nancy.
The judge, sorry. Yes, my wife will want me to make that distinction. So anyway, I began to see that forensic science had to be looked at much more critically than I had in the past. In both Nancy's decision and the one that I made, we sort of compromised a little. So we said that even though we wouldn't allow these experts to say that it was a match, whereas they wanted to say that it was clear beyond, it was clear to a reasonable scientific certainty that it was a match. We would allow them to show photographs of like the fingerprints or ballistics, and the jury could then see at least in a more lay sense what the comparison was. In hindsight, I don't do that anymore because I think the jury is still getting the sense that this guy is saying it's a match and applying quasi-scientific expertise. But it was a step that I took, and then I took a further step later.
So you both spoke and written about just kind of the cultural and structural challenges in bringing Dalbert Rule 702 motions. And, we're celebrating the 30th anniversary of the Dalbert ruling. And we've had this federal rule 702 that reflects Dalbert and adds to it in just amendments. We'll talk about that in a second. But what do you think some of the reasons are why it's challenging and infrequent for the defense to raise concerns about forensic evidence?
One of the reasons I left the bench was that I wanted to write and speak in ways that I didn't feel 100% able to when I was a judge. And one thing that was clear to me was the following. Ironically, the evidence that is tested in court more carefully is new evidence. So DNA, when it was first offered, there were all sorts of decisions excluding DNA because it was new and judges would look at it rigorously. Old evidence, fingerprint, handwriting, ballistics, in fact, because there was precedent over the years of that they were admitted, rarely got that kind of review. So what happens is that if a lawyer would say, well, why am I going to bother, a defense lawyer, why am I going to bother to challenge this ballistic evidence? The odds are the judge is going to say precedent will mean I will allow it in. I'm not going to bother. And if it isn't challenged by the lawyer, the judge can't do anything about it. And if it is challenged by the lawyer, the judge is as likely, even today, to say, well, the chances are if I let it in or I say it's robust cross-examination will deal with any issues, or it's up to the jury to decide weight. I allow it in. I will be reviewed by the Court of Appeals, on an abuse of discretion standard. And an abuse of discretion standard really means that there's a range of options the judge could have come to, and this is within that reasonable range. In fact, the Supreme Judicial Court, the highest state court, had an extraordinary test, which is whether a rational judge would diligently applying the law would agree that this should come in. And so essentially it meant that the only way to exclude this stuff would be as you were basically irrational and you didn't do the job. So in other words, the chances, there was a vicious cycle. The lawyer wouldn't challenge it because the odds are the judge would let it in. And if he or she did challenge it, the judge is likely to let it in because the judge would play the percentages. They'll likely be affirmed in a criminal case because of precedent. And then once there's an affirmance based on abuse of discretion, which again doesn't mean it was right to let it in. It only means it was within the reasonable range of right decisions, arguably. Then that encourages the next lawyer not to bother to challenge it in court because the odds are, well, et cetera, et cetera. So I saw a vicious cycle here with respect to the most problematic evidence that we had never examined before. And I wrote an article about this very problem because I saw it in my court. I saw lawyers not challenging things that they should challenge. I saw lawyers not getting funds from judges to challenge things because, after all, what was the point? And you didn't begin to realize what was going on until much later. The worst case was one of the last cases I tried, where the opening witness, or about the third witness, was a dog. Yeah, it was an arson case, and it was United States versus Hebschi, and the first witness, or one of the first witnesses, was the dog handler. There had been no pretrial challenges to anything in the case. I sit on the bench, select a jury, and all of a sudden, the dog handler is testifying about Billy the dog, who went to a certain part of the room where the fire supposedly started, and literally snorted, he said, in a way that he understood to be a strong signal that that's where the fire started. Snorted. At that point, I excused the witness, and I excused the jury, turned to the lawyer and said, "You're going to challenge this?" In that tone of voice. Lawyer says, "No, I'm good." And at that point, it's very interesting. I mean, a judge, you don't know whether he has a strategic reason that I'm missing. Case goes on. After the snorting testimony, the witness says he wagged his tail in a way he knew to be a strong, a strong signal. I excuse the jury. This is a jury that went to the bathroom so many times that morning. And I turned to the lawyer again and said, "Are you going to challenge this?" At that moment, what the lawyers didn't know is that I used to bring my dog to chambers as a yellow lab, and I happened to know that this dog would snort and wag his tail whenever there was peanut butter on the floor. So, but there actually was a legitimate testimony with respect to canine fire alerts. It's just that was not what I was hearing, and the case went on from there. There was nothing I could do. Very difficult as a judge to say there's nothing you can do, but you can't try someone's case. The man was convicted. Sentencing there were two consecutive 5-year terms. He got essentially a 10-year mandatory minimum. 5 years after and I was deeply troubled by this. 5 years after he was convicted, finally there was a habeas case that was brought to my attention claiming ineffective assistance of counsel. And I wrote an opinion, as I said, United States v. Hebschi, granting habeas relief. But that sort of buttressed my view that there were disincentives. I mean, essentially, the lawyer in the habeas hearing said, "What was the point? I couldn't find a criminal case in which arson evidence like this had been excluded." And that, of course, was true. All of the cases were on the civil side. If your house burned down, the insurance company would say it was, you said it, and the homeowner, having money hanging in the balance, would say, "No, I didn't." And so all of this had been litigated on the civil side. He couldn't find a single criminal case that raises. But I saw then the structural issues, disincentive to raise this, no opinions by district court judges. The civil side law was very different than the criminal side law because there are resources there. I don't know whether it was, actually, that was one of the cases that led me to issue a procedural order, not with respect to arson, but with respect to ballistic testimony, where I required a hearing. If there was any trace evidence in a case or matching evidence, again, not the arson case, but with ballistic cases, I wanted to do something so that I would seize control and require people to litigate issues in advance. I didn't have a chance to see what would happen with this, because then I decided to leave the bench so that I could speak. And I speak. Although Rakoff speaks, even on the bench. But I always got in trouble if I spoke. I always got in trouble.
So first, as a pet owner, I want the record to reflect that I only think cats should be allowed to testify. But secondly, so a big sea change in how I approached all this was the Dalbert decision, which came down the early 90s. Up to then, as many of you may already know, the standard everywhere was the so-called Fry standard. Expert testimony, not just forensic testimony, but any expert testimony of a scientific nature was accepted if it was generally accepted in the relevant community. There was a big debate of what was the relevant community. But this meant there were tons of precedents in most states. And so you, as a defense counsel, there was no point often in raising a challenge because there were 50 years of acceptance of this particular kind of evidence under Fry. Dalbert changed all that, but it was not so obvious initially how great a change it had affected. What it said was that under Rule 702, judges had to make a much more rigorous inquiry and basically decide whether it was reliable science or junk. There were subtle pressures that made that much harder to apply in criminal cases than in civil cases. And I'll give you an example. One of the first opinions testing forensic science under Dalbert was written by Judge Pollack of the Eastern District of Pennsylvania, former dean of Yale Law School, but we forgive him that, who initially held that fingerprinting, which had been the, quote, gold standard of forensic science, did not pass the Dalbert test, and he excluded it. Well, there was a huge outcry, not just by the government, but I can remember one of the respected judges in my court in the Southern District of New York saying to me, "Did you hear about that crazy judge who threw out fingerprinting evidence in Philadelphia?" It was so at odds with the tradition of letting all this stuff in that it had not yet penetrated the minds of most judges. And Judge Pollack, I don't know whether it was because of pressure like that or just independently, he then issued granted a motion for reconsideration, and he let it in. To this day, the challenge is by a defense counsel in criminal cases under Dalbert are much less successful than the challenges by defendants in civil cases. Part of this is, as Brandon pointed out, is money. But part of it also is, I think, a worry by state and federal judges. Gee, it's a criminal case. Am I going to keep out this critical evidence that might make the difference between conviction and acquittal? Will I be viewed as soft on crime, God forbid. And remember, in many states, judges are elected. So that's also an element. The other change that Dalbert affected, a little more subtle, was that those who did challenge it got a chance to challenge it before trial, often at the summary judgment stage in a civil case, for example, or a pretrial proceeding in a criminal case. And since the overwhelming majority of cases settled, both civil and criminals, the statistics are something like 97% of all cases settle, both civil and criminal. If any of this was going to be seriously evaluated, it had to be evaluated pre-trial because the case was never going to go to trial, but it would affect the settlement materially, whether it be a plea bargain or a monetary settlement. And that only slowly began to dawn on people that this was an opportunity to shape the settlement that they knew they were going to ultimately enter into by making these challenges earlier. But it took many years for that to penetrate.
The irony is that Dalbert, which would be incredibly important on the criminal side when liberty is involved, winds up being used on the civil side for the purposes of summary judgment to be able to narrow the cases. More often it's deployed in that setting than it is on the criminal setting for the reasons that I described.
By the way, just so everyone knows, Dalbert is pronounced Dalbert. I used to say Dalbert. Snobs say Dalbert. But Mr. Dalbert is on record as saying that he pronounces his name Dalbert.
There you go.
The Supreme Court decides.
Right.
I'm really interested in hearing. I want to start raising your hands, students, if you have questions, and I'll stop asking questions. I could pause now and see if you have any. I have a few saved that I would still like to ask, but we don't need to get to them.
We'll answer anything, or I can answer anything. He may be constrained. Ask me anything.
Yes. Yeah, Magnus.
Hi, I'm Meghna. I'm at UL at the law school, and I just have a question.
Only one more year till parole.
Exactly. I just had a question about emerging and new types of forensic evidence and the technology being a lot of courts. You were talking about how new evidence is kind of tested more than old evidence. And I was wondering what kind of expertise under Dalbert might be needed to testify to some of these emerging techniques or emerging issues, particularly, I'm in Professor Garrett's AI and criminal justice class, particularly AI. Do you think evidence like that will have a tendency to be tested more? Do you think that there's a higher level of expertise maybe than maybe required under the regular Dalbert standard, especially considering I would imagine how few people are actually experts on things that came out a couple months ago. So I was just wondering what your thoughts were on that.
Well, I think judges need to be careful about new science because the historical record is they've often been burned by bad science that was new. Back in the 19th century, for example, there are a number of cases where a person was determined to be insane or not insane based on phrenology, which was the science of the time that you could tell a person's mentality by the bumps on their heads. In the early 20th century, the Supreme Court, in fact, Oliver Wendell Holmes, in a case called Buck v. Bell, approved the forced sterilization of a woman on the grounds that she had inherited imbecility and would give rise to imbecile children. And this was based on the hot science of the time of eugenics, which frankly was widely accepted until it was adopted by Adolf Hitler, and then people took a harder look at it. In the middle of the 20th century, a Portuguese scientist won the Nobel Prize for developing lobotomies, whereby the portions of the brain are severed from other portions of the brain, and it supposedly helps cure severe brain pain and depression. 5% of those, there were 40,000 lobotomies in the United States between 1940 and 1960. Many of them court ordered, many of them of people underage, and the 5% of those died on the operating floor. Another 25% became human vegetables. And it wasn't until the 1964 presidential campaign where it came out that Jack Kennedy's sister had been lobotomized at an early age at the behest of her father, Joseph Kennedy, and had been essentially a vegetable ever since, that people began to take a harder look at lobotomy. So I give those examples to show why I think a caution is required when you're dealing with new science. A much more recent example is neuroscience. And I had the great privilege of serving on the governing board of the MacArthur Foundation's Law and Neuroscience, the Foundation's project on law and neuroscience. And there was an attempt in both in New York and in Tennessee to introduce so-called neuroscience lie detectors. And this was based on research where supposedly you could tell which part of the brain was most active when you were lying as opposed to when you were telling the truth. And there were a lot of serious methodological flaws in those experiments. But two of the scientists who had done those experiments formed companies. One was called CFOS, the other had a great name, No Lie MRI. And they attempted to get this into evidence. The MacArthur Foundation project decided this was bad science, and so we sent our own experts to the court to ask to be heard as to why this bad science, and in both cases, it was ruled out of evidence. But my point is, new science presents a great challenge for courts. It doesn't mean it shouldn't be included if it passes all the tests, but a certain caution, I think, is required.
My initial point was that it was ironic that things like bite mark testimony and handwriting analysis easily came into court because it had always been admitted. And then DNA, when it was first proposed, there are all sorts of hearings with respect to its legitimacy. And to some degree, it ought to be the reverse. AI offers, I think, interesting challenges. There was a case, I think it was involving sentencing software, where the question was, the parties involved wanted to know what the algorithms were that the software used. The problem was that it was a proprietary program, and the court actually refused to provide the underlying data because it was proprietary. With respect to AI, the underlying data may be critical, and the algorithms may be critical. And so the question is, will courts be able to, should they unpack? I think the answer to that is yes. And how they unpack and with what they unpack the program, how they do it will be essential. So there's no question that has to be looked at. Neuroscience is very interesting because the neuroscience is also on the MacArthur Network, and I teach law and neuroscience, and the neuroscience testimony is actually very interesting now, putting aside the no lie MRI. But the court is neuroscience show averages. They do not show what's in your brain. They look at whatever is in your brain through the machine and then analyze it in terms of averages for brains that have gone through MRI. So it doesn't ever speak to what your brain is like, but more what averages do. That has been admitted now admitted as a broad term, but to some degree that has been used by the Supreme Court in determining that juveniles, for example, should not get the death penalty or life without parole. More recently in Massachusetts, that testimony has been used to show that 18 to 20-year-olds should not get life without parole, partly because the generic neuroscience testimony, which is talking about groups, maps onto these generic rules. And the question now that courts are going to have to deal with is, how can we use this data for individuals? And the science is not up to that yet. But again, it sort of shows the broader point that, innovative science tends to be looked at much more carefully, as it should be looked at. And we take as an article of faith the gang expert who testifies about gang language, or the FBI agent who testifies about drug language, that is rarely examined and certainly rarely excluded, and it's all experiential and not tested at all. So I think AI will be looked at critically. I think it will be hard, but it will be looked at critically. The challenge is to look at all of forensic evidence critically.
I just want to follow up on one point. The case that Nancy was referring to involving an algorithm that was used to determine risk of recidivism went all the way up to the Wisconsin Supreme Court, and they, in my view, wrongly decided that because it was a trade secret in a competitive market, not even the defense lawyer was entitled to know what went into the algorithm. Now, I think a better solution would have been to say the defense lawyer should be able to look at that and his expert, but on an attorney's eyes only basis, so it wouldn't affect the competitive marketplace, but he could still challenge it, but he wasn't able to. So it's another example of how new science presents unusual challenges.
Yeah, Jack.
Hey, my name's Jack. I'm real. I have a question about application. I feel like it can often be easier to figure out what kind of science is not reputable. Something like
A little louder.
just that it can sometimes be easier to figure out when science is not reputable. But I have a question about application. What do you think judges can do to make sure that experts are actually reasonably applying, something like arson evidence? Because as we're talking about, it can be applied correctly, but it can also be applied in a way that sends someone innocent to jail. So I was wondering about your thoughts on how judges can apply this in the right way.
So a big aspect of that, I think, again, lies with educating the defense bar. So in civil cases where typically the defense has a reasonable amount of money, they can hire experts who will then be able to make a Dalbert claim and a Rule 702 claim, because Rule 702 says that it's not just that it has to be scientific, but it has to be consistently and properly applied in terms of methodology. On the criminal side, Rule 16 has just been amended. Prior to that time, the prosecutors only had to put in like a paragraph. Our expert will testify to X, and not how he or she arrived at it, not how the methodology was developed, and none of that. Whereas in a civil case, an expert report is often 20 pages. And the Rule 16 was just amended, took effect this past December, and now requires a lot of the same disclosure. So some of us are hopeful that that will allow similar challenges on the defense side, but remains to be seen.
But I think partly what Jen and I talk about is the disincentives to challenge on the criminal side are very substantial. One would think that liberty would lead you to, in someone's liberty is at stake, you would challenge more. But when we talk about almost 97% of cases, I think it is on the federal side now, plead guilty. appointed counsel, not public defenders, but appointed counsel rely on the judge allowing funding for experts. They have to apply to the judge to get funding for experts, and some do, some don't. So it's sometimes not a question of what the framework is, because there is a framework to challenge, and now with the new Rule 702, a really good framework to challenge. But sometimes the question is the pressures of trial and funding create disincentives to challenge. That has meant that some of what we are talking about in the conference is that that's why, to some degree, that the action has often shifted to having forensic organizations or statistical organizations or the testifiers themselves, the FBI, the DOJ, I mean, the FBI mostly, come up with their own standards because, in fact, courts have not been very good at enforcing those standards for the reasons that I've described. The NAS report that Jed talked about how abysmal the courts had been in enforcing the rules. Part of that, as I said, is a function of what I said at the beginning, which is precedent somehow trumps science with respect to some areas, and some of it is a disincentive to challenge. So you have to deal with not just the standards, but you have to create the incentives to challenge and to apply the standards. And then in addition, we have to deal with the expert organizations so that they can regulate themselves, because sometimes the courts are not the best at doing that.
And I don't want to get too far afield from the main focus of this discussion, but 40% of the federal criminal docket is drug cases. And in those cases, they're mandatory minimums. And so frequently what defense counsel is chiefly focuses on is how can I negotiate with the prosecutor a plea to a lesser mandatory minimum. If you say to the prosecutor, give me 3 months because I want to hire an expert to challenge your forensic science, he's going to say, well, that's fine, but then instead of the 5-year minimum, the best I'll give you is a 10-year minimum. So you go back to your client says, let's take the 5 years and be done with it. So there are a lot of built-in disincentives, as Nancy points out, to these challenges.
More questions? Yes.
Hi, I'm Scott. I'm a 3L. And I'm curious if, given those differences you mentioned between the criminal and civil context, do you sometimes view forensic evidence differently based on the context? For example, are you maybe less skeptical of forensic evidence offered by a criminal defendant because of their liberty at stake versus a prosecutor or a civil defendant?
Less skeptical?
If it's being offered by a criminal defendant.
I think, there's a broader discussion. I think many judges are more skeptical of evidence presented by the criminal defense side. I had been a criminal defense lawyer. I did not have that. I didn't see that in the same way. But prosecutors' experts are oftentimes, the prosecutor is a repeat player in the courtroom. The prosecutor is much better funded. And so oftentimes the balance is just the opposite, where a judge would be more skeptical of defense experts. Shouldn't be, but oftentimes, oftentimes is. One of my former colleagues on the bench there was a challenge to a confession. And there is actually an abundant social psychological literature about the circumstances under which a confession can be skewed, the way in which someone will falsely confess. And there's experimental research, social psychological, not like DNA, but it nevertheless is reports in reputable journals. The judge rejected it, offered by the defense to say, here are the factors that led to a false confession. The judge rejected it, and then in a decision described it as junk science, which is just not remotely the case. The prosecutor didn't need to introduce evidence to show the legitimacy of the confession because it was always introduced as appropriate. But the defense was dealing with a judge who was looking at this as junk science. So it's really the reverse of what you're saying.
I see.
I'm delighted you asked that question because it gives me a chance to reference an article that Judge Gordon Liu and I wrote and was published in the Proceedings of the National Academy of Science in October of 2023. And please go buy yourself at least 5 copies. So we looked at the last 300 federal cases in which Dalbert challenges have been made to scientific evidence. In the civil cases, those challenges were successful 25% of the time, about equal for plaintiff and defendant. In the criminal cases, the challenges by the prosecutor were successful more than 90% of the time. The challenges by the defense were successful less than 10% of the time. So clearly, judges, for whatever reasons, and we speculate in the article what the reasons might be, but are very skeptical of defense challenges in criminal cases, much more so than I think they should be.
Thank you.
Yeah, Gene.
Thank you both so much for being here today. As small background to my question, there's currently a federal class action lawsuit in New Jersey against the state of New Jersey for collecting newborns' blood and then keeping it for 23 years without informed parental consent. And so, with that in mind,
Well, this is anything goes in New Jersey. I mean, come on.
So I worry as we shift in our courts to more focus on DNA because it is more reliable evidence, what kind of guardrails we can put up to protect against regimes kind of trying to obtain, store, catalog people's DNA, often against the individual's knowledge, which is basically what's going on in New Jersey. And there's some precedent. There were other cases in like Texas and Michigan and Minnesota. So it's not just happening in New Jersey.
They're keeping the DNA, doing DNA testing of the material. Is that what they're doing? And they're keeping it for 23 years?
So whenever, this is state, like nationwide, whenever a baby is born, there's a heel prick, and the blood is tested for over 60 genetic disorders. And that is like in every hospital across the country. But some states are then storing that blood and not like against the parent's knowledge. And in New Jersey, it just recently came to light that they're storing it for 23 years. And that without the parents. And so it kind of like became known because they actually, in at least one case, used that DNA in a criminal case to link the father in a sexual assault case. And so that's kind of like the background. So I just worry that since DNA is so much more reliable, which is wonderful, I mean, I don't think anybody is contesting the use of DNA. I just wonder when we're talking about incentives and disincentives, if it will incentivize institutions to harvest DNA in ways such as this.
I'm on the Massachusetts Forensic Science Oversight Board, and one of the things that we're addressing there's a statute dealing with DNA collection out of criminal cases that deals with what's the appropriate use, what can go in, and what's the appropriate, and how to take information out. But the problem is, one of the things that we've been dealing with in my board is that I don't know whether it's Ancestry.com, but one of those institutions is not so clear to the people donating their DNA that they can be shared with the government. And in fact, some of the databases, in fact, took information from voluntarily given DNA samples up until, essentially DNA can be collected with someone who is convicted. Massachusetts, I believe it's now arrested as well. But these are people who had voluntarily given their DNA. So there's a question of, in other words, the regulation that we're doing is coming from a board with limited enforcement powers. And then there's regulations with respect to what one does with the database of DNA, what can go into what kind of analyses, difference between familial searches and YSDR searches, et cetera. So, but that is going on, at least in my view, and actually the expert is here, maybe Peter Newfield would know more, less in court than it is in boards and agencies that are trying to regulate its use.
So I may have a slightly different view here, although Nancy is clearly much more up on this than I am. But thanks to the collection of DNA by federal and state governments, most of which is people who've been arrested or convicted, so it's not voluntary, and but it's doesn't invade privacy in quite the same way as some others. Many of the people who've been exonerated by the Innocence Project, not only have they been exonerated, but law enforcement was able to then buy the DNA to determine who committed that terrible murder or who committed that terrible rape. So it's been a great tool for arriving at the truth in many of those cases. Now, I had the following experience, and bear with me because this will take a few minutes to explain. But so 5 years ago, my younger brother, who is a professor at Harvard Law School, but we overlooked that. It's because he's a lot smarter than me. Anyway, he gets an email, and the email says, please forgive the intrusion, but I think I'm your half sister. And the author then says that when her mother died a few weeks before that, her mother had revealed that this woman, Barbara, was the product of artificial insemination. She had never let her know that while her husband was alive because she didn't want to disrupt the family connection, so to speak. So Barbara then sent her DNA to Ancestry.com. And Ancestry.com said it's a perfect match for my cousin Kay. And how much consent there was by Kay, I don't know. But anyway, so Barbara then did some research, and she said, I discovered that there are 3 possible males of the right age who could have been the persons who made the sperm donation. Kay's father, but he was killed in World War II, and it was close, it would have had been in a very short time frame that this happened, so probably not him. Your Uncle Frank, but Frank, I understand, is an accountant, and I don't think accountants give sperm donations. And your father, who was a fertility specialist. Now, I knew from my father that in the early days of sperm banks, they had trouble getting donations, so they went to medical schools and paid $25 per donation. And my father, being poor, made numerous donations. So this all sort of fit. But of course, he had been promised privacy by the sperm bank. So my brother said, maybe this is a scam. So I did a little investigation of Barbara. I discovered that she was a prominent businesswoman in San Diego, married to another prominent business person. And so I told my brother, hey, we can reverse the scam. But anyway, since that time, we've had contact with this woman, and she's a lovely woman. But really, it was nevertheless, if you think about it, my father clearly had been promised privacy, and yet DNA had disrupted this, and not through government action, but through the action of Ancestry.com. So the issue you raise is a real one. And I wonder who else is out there, since my father gave several donations.
Raise your hand if you're related to I mean, I think that there are, again, as I said, there are lots of issues to be regulated. You hear a great deal about familial searches, and familial searches then put within the government radar the relatives of the supposed suspect. And if the question then becomes who's in the DNA base, is this going to be another basis for sort of sweeps in minority neighborhoods? Because now all of a sudden X is on the government's radar screen because of a familial connection. So there's a lot of issues that need to be examined. My sense is that it may best be examined initially, not by litigation, because for all the reasons that litigation, particularly on the criminal side, is fraught, but will have to be statutory or regulatory, assuming regulation survives this current Supreme Court. So, but at least statutory. So no, I think that there are lots of issues. You raised some of them.
Time for maybe one or two more questions. One more?
Yeah, there we go.
So I'm wondering what you'd like most to see judges focus on in order to combat some of these problems. Do you think more standing orders, more opinions, more judicial education? Like what would you advise if you were going to focus on one or two potential solutions?
Well, I have an opinion about this. I have an opinion on everything. My father used to say that some people had hardening of the arteries. I had hardening of the opinions, but that's another. I think it's ironic. Most of the training with respect to forensic evidence occurs with trial judges. And I think that training has to occur with appellate judges, because the regulatory framework for district court judges is in fact provided by the appellate courts. And unless the appellate courts begin looking critically in two respects, looking critically at evidence that's admitted and also looking critically at the lawyers who fail to raise these issues. So in my arson decision, the lawyer was perfectly competent in cross-examining a witness, but he had not done any of the work that would have informed that cross-examination, namely a challenge to the arson evidence. And my decision was saying that this was ineffective assistance of counsel. For certain kinds of areas where technical evidence is critical, his toolkit had to include at least holding a hearing, asking for a hearing with respect to that. So there has to be changes in ineffective assistance of counsel so that lawyers will know that they must address this, not just may or not just sometimes. And then we also have to deal with the appeals court so that the appeals court can then look more rigorously at this. Because unless the incentive structure changes, and what's the incentive structure in criminal law? The conviction will be overturned. That's the only incentive structure we have in criminal law. Unless that's done, I don't think there will be significant changes, although I'm incredibly hopeful at Rule 702, looking at one of its drafters. But I think I have to say that today.
So I want to respond to that, and I agree with Judge Nancy, and I think the Supreme Court made a mistake when they said that the standard of review for Dalbert decisions should be abuse of discretion, even though as a district judge, I'm a beneficiary of that, so to speak. But most of these do not involve credibility determinations or demeanor issues of the sort where you have to be the guy on the spot seeing the witness. But the result is that you have district courts in the very same circuit going both ways on basically the same issue, and they're both being affirmed because it's not an abuse of discretion. And so I think you'd have much better and more consistent law in this area if there was de novo review. I think could come about. I have one other suggestion which I made many years ago, which is not going to come about, but I'll mention it anyway. So this is when I was a young AUSA. It was right after Watergate, and Edward Levy, the former head of the University of Chicago and a great attorney general who helped turn things around after Watergate, came to talk to the prosecutors. And I said, what do you think about, to make it a more balanced system, if every prosecutor had to spend 6 months out of every 3 years as a criminal defense lawyer representing indigents in another district so there wouldn't be a conflict? And I still think that would lead to a much more balanced system. Edward Levy, being a law professor at Hart, turned to me and he said, well, that's not a wholly bad suggestion, not wholly bad. So there you are.
Although this is to law students, if the standard of an affirmance is abuse of discretion, that doesn't mean that in the case you have, the rule is now the rule that was articulated. It only, in other words, lawyers will sometimes take abuse of discretion decisions and go into court and say, well, this is what you judge should do. And actually, it isn't. It's a notion of what the range of reasonable determinations are, but it doesn't necessarily mean that this is the right one. There's an article called Deference Errors that talks about that, and I think that that's an issue for lawyers as well.
Let's stop there. Our lunch hour is over, but thank you so much.